It is clear that this period has to be exacted. It has to be excluded.
But this has not been,
We are giving you a date, you will have to wait.
Lord, my
We are not inclined to entertain.
Your Lordship will keep it pending. Your Lordship will keep the application pending. Your Lordship will not say anything about the bail application.
No,
Your Lordship will consider it on the date.
We are not entertaining it. 17780 of 2025 is accordingly listed as the matter is right for hearing. The registry is directed to list the appeal for hearing on 8th October.
Your Lordship will kindly, I will not dismiss at this stage, will not, so that doesn't.
8th October, we are hearing the appeal. Be ready.
Lord, on 28th April also, Your Lordship had said.
Specific date. Earlier, week commencing meant it would come perhaps during the week or beyond. Now you will join the queue, so be ready when the matter reaches.
I'm grateful. Please. Today he is in prison for 12.5 years. 12.5 years. 11 years. 12.5 years.
Somebody wants to exaggerate the period of incarceration. Earlier counsel, now you're also doing it. How long was he actually inside? The precise figure will give us, not embroidered figures.
Lakshma, can you calculate 74 months? 11 years, 3 months, and 11 days.
In your eye?
15,424. 74, page 74.
74 of the SLP.
Yeah.
Yes.
Custody certificate. Total period 11 years, 3 months, and 11 days. As on 15,424. Now, that's only have gone after that. Therefore, I submitted it is more than 20 years.
You've not been granted parole at all?
No problem.
At all?
Yes.
Is that possible?
But the problem is this.
No, most of these custody certificates, they don't seem to disclose the correct details in terms of the period that you were allowed to go home. At least in that earlier one, the details were furnished, though the deduction was not made.
We go with this only. One more problem in this matter is, so far as the other accused
who is appearing against you, notice was issued on your application also.
Notice, sir.
Notice.
Sir, served on them. Officer put
29,720. Not sir. Service not complete is what?
Sir, but you read, sir, you please read the note.
Complete.
He was in jail in some other case. Please read it.
Well, that case on 25/10/2020.
Will have to be deducted too.
Concurrent.
This was a separate offense altogether.
Yes. Separate case.
But you have to verify.
This is not a concurrent sentence.
No, you have to verify.
You were already in jail in relation to some other offense. So this sentence will commence after you complete that.
No. You don't know what I
And in this case, he is in jail.
Not the court will give concurrent finding, concurrent sentence. That is to verify.
Anyhow, there is no ramification for the state. Without the state appearing, we are not going to entertain
One more thing, Lord Smakaili, consider it.
anyone for the state of Jharkhand. Service is complete as per the office report. Nobody is engaged to appear.
I am not engaged in this matter.
But the state needs to be a little.
I can seek instance. I can seek instance. Please.
Whereas may submit one.
There is no representative
There are
for
only
the
one.
state of Jharkhand.
Then you ask.
Despite service of notice, Mr.
Dr. Sudhir Bisla.
Dr. So-and-so, counsel, who is present in court, states that you're a standing counsel?
Yes, ma'am.
He is a standing counsel for the state of Jharkhand, but he has not been engaged to appear in this matter. He, however, offers to obtain instructions and appear in the matter if instructed to do so. We accordingly adjourn the matter to enable the state of Jharkhand to respond to the plea of the petitioner for grant of bail pending the special petition.
2 weeks for.
This how much time would you require?
2 weeks is sufficient.
This on 10th September.
One small submission that I will make, you will kindly get me for this. There is difficulty, no point in
No, I'm not
you're saying
saying
anything.
we will not be able to remember till 10 September, so why do you estimate?
There is another accused, but his appeal is pending in the High Court, therefore this cannot be disposed of. It's a problem.
His appeal is still pending.
Yes.
You know, we are not disposing it of. You only said, you're in.
Please,
Whatever you need to say, say.
please.
Let us get instruction on that also, that's why it is. That's all.
Appeal.
Please.
So also there's some confusion.
Yeah.
He is still in jail, is it?
Still in jail, my lord, but the stay has also been served to his wife also as well as in the jail, my lord. There are 27 matters pending in this matter.
No, but service is complete by way of Dusty service.
Yes.
Dusty service inside the
That's
prison.
inside the prison as well as his wife also, my lord.
And no one is appearing.
So no one is appealing. But kindly, I have page number E, my lord. There is 27 cases.
27
presented.
From the photos. Service of notice, the respondent has not chosen to enter appearance. The Supreme Court Legal Services Committee is requested to engage a learned counsel to appear on behalf of the respondent as the matter pertains to cancellation of receiving list on 17th September.
17. Please.
But this matter comes up.
So district judge
Framing of charge appointed.
district judge has been appointed.
3rd September is when it is for framing consideration of that.
Then we'll adjourn the matter. at this stage.
But
Your discharge application is pending.
not,
If we say anything against
No,
you,
Lord.
it may weigh against you
I-
there also.
not but
So
today,
your own interest, I think it's better that we adjourn the
can
matter.
I just make one request, Lord? The High Court has said everything that needs to be said. See the High Court order. Today, not after this, what am I going to get? Let's just see the High Court order. And it's a DA case where the amount is, it's a trap case where
Which
the.
paragraph of the High Court order?
No, Lord, just see this. Lord, if my Lord just gets the High Court order for a moment, please just come to para number, Lord, 14 onwards. Sorry, that's 14 is this one? I just can't. Yes. 31, Lord, 31 will be at page number 7. 31 onwards.
These
And
are all general observations.
Lord, now come to
10,000 স্টেপস হ্যাঁ এই কোথায় গেল
judges.
Special judges.
Special judge, Lord, it has to be special judges.
Has now been appointed. And the discharge application filed by the petitioner, which is directed to be listed in the month of September,
3rd September, Lord.
on
Lord,
3rd September 2020,
Lord, may I just say,
is now capable of being taken up for hearing and disposal. We accordingly adjourn this matter, leaving it open to the trial court, but the special court to deal with the said application on its own merits and in accordance with law, uninfluenced by any of the observations made in the impugned order and the pendency of this special.
well, not just one request, Lord, I believe, not here, not in the northern states, we don't move discharge, it's argued on charge. So my Lord, we just say consideration of charge is restricted. It's listed for arguments in charge. Here, we don't move
It's not a
discharge.
discharge.
Lord, it's arguments in charge.
On arguments. On the
Not one
of
thing.
charge.
One more thing I must point out, my learned friend can verify this. I have the order of the Honorable High Court directing him to be appointed as special judge subject to consent of the state government. we've not been able to locate the consent of the state government. My learned friend may just verify that because that's the only catch.
Is he taking up matters or not?
But he's taking up matters, but till the empowerment happens, that may be an issue. That because we tried, we couldn't get the
Not even
notification.
let us see whether he says something.
Grateful, deeply.
So this complete.
This case, Lord,
This is complete. No one is appearing for the state.
No,
Again,
no.
Jharkhand.
a clutch of papers, documents to show that I'm cooperating, Lords. So the other side is not clear, so I'll,
Jharkhand.
because I have an interim order.
Council has also gone.
So if 1 month, Lords, I'll file these documents, Lords.
There is no representation for the state of Jharkhand despite service of notice. This is the usual case so far as the state of Jharkhand is concerned. Notice may be sent by the registry to the chief secretary of the state of Jharkhand to take note of this careless act, also careless, lackadaisical attitude on the part of the state in entering the parents before the Supreme Court.
Interim order.
List on 7th October, earlier interim order should continue.
And I'll be permitted to file.
21/7/2022 shall continue to operate in the next state of year.
Well, I'll file some documents, Lords, to show that I was cooperating, Lords. Or should indicate that.
Then counsel for the petitioner is at liberty to file additional documents, if any, by the next state of year.
Steve?
Portrait pleased to issue notice on 21st July. They had filed a count that day.
Counter is fine.
Yes, sir. Yes, Your Lordship. It is not
When?
someone recorded. Your Lordship, it is not someone recorded.
You need to file a rejoinder, not this. Then counsel for the state states that state of Rajasthan states that a counter affidavit was filed on 26th July.
Yes, Your Lordship.
26th July. However, July.
No, yesterday.
Yes.
Obviously. However, we do not find the same in record. Then counsel for the petitioner states that he does not wish to file a rejoinder later. For the state to verify and put up the counter by the next state of hearing. This is also bail. So we'll take it up on 10th October.
Grateful.
Sorry, 10th September, not October. 10th September. Bail matter.
I'm playing for Passover in this matter because when argument council is occupied before another bench,
You can argue. You can argue.
I can't.
You can't. Why not?
I'm not ready.
You're not
Ready.
ready. Are you not attached to his office? Are you not attached to the office of the AOR or the arguing council?
I'm attached, but I'm not ready. No.
Not ready in the sense you read the papers, but you are not ready enough to argue.
But I'm not also have the file.
You don't have the file,
Yes.
but you must at least carry the file. What do you have with you? You're carrying your iPad, is it?
Yes. Sir.
Then on the iPad, the file must be there.
But just half an hour, I got the brief from the senior council.
When? You didn't read it.
Yes.
But unless you read the briefs, how will you follow what is happening? You've not read this file at all.
Yes.
That is bad. When did you get it?
It's on 20.
22. 22. 3 years have passed then.
Yes.
And you're not reading the office briefs.
Yes, sir. Recently, I joined this office.
You recently joined. But that doesn't mean that you don't read the office briefs. You must read the office briefs, isn't it? You never know when you will be called upon to argue. Must it?
I joined this office.
You're only spending time.
This office.
You're only spending time here while preparing for the mains.
Yes.
Civil services.
Yes, sir.
But even for the civil services, you need to have more application of mind. Anyway, then comes for the petitioner seeks an adjournment on the ground that the arguing council is held up in another court. List on 24th September.
Let me explain. Well, this is an anticipatory bail application in a case where I've been claimed for the abatement to
This
suicide.
dying declaration to the executive magistrate. You've not filed it.
We just point out.
Why have you not filed it? You've not filed a copy of the dying declaration.
Because we do not have the copy.
How can you not have a copy?
Because that's the police, that's not, this is the anticipatory act.
I appear for this.
At this place that time declaration.
For the complainant.
Complaint.
You are for the complaint.
Yes, ma'am.
State is not.
These are at KBA. My lord, these
I'm
are
not
fresh.
I was heard by the
It's a fresh-
Honorable High Court also.
You were heard by the.
Honorable High Court, my lord, I was heard.
When you appear before the High Court, at least ask the High Court to implead you.
Yes, my lord. Lordship, sir.
That's not happening because the cost title doesn't reflect the name of the complainant.
Lordship.
Complainant's counsel is heard.
Lordship, sir.
But he won't be made a party here because he's not there in the area.
Lordship, sir. I was heard with that. And I filed written objections also which are not on record.
So, my lords,
You have a copy of that time declaration.
That I also don't have, my lord, because the trial court, my lord, it's part of the trial court record.
not even trial court, it's still the.
In the investigation.
It's part of investigation,
Yes,
yeah.
The complainant who is on KBID is in pleaded form of as respond number to give the details.
Yes.
As he was heard by the High Court while passing the improved order. Issue notice to the state of Gujarat, the on 17th September. This is an anticipatory bill. Normally we would grant protection. What do you have to say?
On 14th of August, my lord,
Lord, we,
an application was
That is what he has to say against you.
and on 14th by the police officer before the learned trial court that, my lord, all the petitioners are absconding. A statement is made in the synopsis that, my lord, they are ready to cooperate, they will investigate and they will appear. But on 14th of August, an order is passed by the trial court that they are absconding, my lord, from the trial. Therefore, my lord, custodial interrogation is required.
Now
My
we
lord.
have only one brother before us.
My lord, there are two other SLPs also filed which
The
are
wife and the other brother.
and the other brother, which are in defects, my lord. All of them will appear, my lord, perhaps someday. They are not cooperating, my lord, since April.
These are people who have been married for a very long time.
26
Their children
years.
are 25 years old, 20 years old.
He was mentally, my lord, harassed, because of which, my lord, he committed suicide by endorsing fire.
The FIRs by the wife against him.
My lord, those are 2022, my lord. I am instructed to say that there were many FIRs, my lord, between the parties, my lord. He doused by fire, my lord. He put kerosene on himself. The most difficult form of, my lord, suicide that was committed by him. He was harassed, my lord. That is the reason I am opposing.
It's 10 years old.
and we also sign.
10 years.
10 years.
10 years. Cooperate with the investigation. At this stage, perhaps incarceration is not.
Your lordships are dismissing this.
No, we are not discussing, we are granting an interim bail also.
Lordships will consider hearing me after notice on the date.
You file your reply.
If I would
There's no
reply till
point
then,
in sending
let
somebody
him
like that.
cooperate with the investigation.
They have not,
Should not be arrested.
since 9th of April until the,
You direct
they just take this. From 9th of April, my lord, when this act had occurred, they had once, my lord, come for the ceremony, my lord, which was funeral. After that, my lord, they have not appeared. This is the order by the
You
trial.
have the petitioner's complaint against the deceased on 9th September 22. Then Rita Ben's FIR, the wife's FIR is on 11/2/25. 9th April, he commits suicide.
All of those are 2022.
Really, because they filed criminal complaints against him. If he committed suicide, that is not perhaps a ground for a 306 conviction.
Sorry, the suicide had occurred in.
Now you have Justice Vishwanathan's judgment on 306. So unless you pass that standard, a 306 perhaps conviction would be very, very difficult. Abatement of suicide, you need to really put it beyond the pale of doubt that this person had no other option because of the action of the accused except to commit suicide.
The FIR will not
Really saying that he was depressed and they did something so it added to his depression. Those are all subjective standards. You never know what will drive a particular person beyond the edge. If it is that subjective standard, 306 conviction won't follow.
And can I just show the FIR, not just for 1 minute, may I just show the FIR? At page 68, your lordships will have.
Page
60 of the SSC.
Then my lords can see page 58 also, the bottom line from the 58.
60 will come after. So
let us see what they want us to show also. See also.
My lords, page
Taben,
58.
58.
The last bottom line, second line I'm talking.
Rajesh Bhai Thakkar also.
Ago, my brother Prashant Bhai came to my home. He sat with me and my mother and said that he was fed up
Where are
with
you
his life.
reading?
Lords, page 58, last 2 lines.
Last.
Lords, got that?
Yes.
About 15 days ago, my younger brother Prashant Bhai came to my home. He sat with me and my mother and said that he was fed up with his life. He stated that his wife.
You said that they did nothing about it, though they knew that he was feeling depressed.
15 days back, he comes and makes a statement. He is in a close proximity with the victim, and he was not.
60 minutes.
60.
Yes, Milord. My brother told me that for a long time, his brother-in-law Rajesh Bhai Thakkar and Bharat Bhai Thakkar, along with Bharat Bhai's son Jamin and his wife, had been pressurizing him to become a Ghar Jamai. He said that they had also forced him to transfer all his property and bank lockers to his wife's name. He also said that the house in Tirupati was also in the name of wife Rita. Furthermore, he stated from the partnership business, they were in partnership together. They owed him 73 lakhs while he owed them so and so. He stated that to avoid paying him this money, they were pressurizing him. They had also taken a loan of approximately 35 lakh on his house in Tirupati and had taken his Activa scooter also. He said that for the last 2 to 3 days, these people had been repeatedly threatening to kill him if he did not vacate the house, which made him very frightened. So he had bought petrol from outside, doused himself, set himself on fire, and ended his life. I recorded a video of this conversation on my mobile phone, which I will present for the purpose of investigation. My brother had also previously sent me a 5-page letter on 22/1, in which he had mentioned the mental harassment he was enduring from his wife, Rita Ben, and his brother-in-law. I am submitting a copy of that. I have also learned that my brother Prashant Bhai had posted an audio message on his society's WhatsApp group before setting himself on fire on 9/4, stating that he was burning himself because of the harassment from his wife, Rita Ben, his brother-in-law so-and-so, and Bharat Bhai's son so-and-so. My brother Prashant Bhai, resident of so-and-so, due to the harassment from these people, doused himself with petrol, set himself on fire inside his house on the morning of so-and-so. Then your lordships may see, my lord, the trial court order where, my lord, they had applied for the bail. That, my lord, your lordships will get.
Page?
Yes, my lord, I'm sorry. The analysis is at, my lord, page 159, but the order is, my lord, at 144, my lord.
You want us to see 159?
My lord, yes, my lord, the order begins at 144. The analysis of the learned trial court is at 159.
Yes.
After considering all the arguments of all parties and police papers and looking at the facts on record, it is clear that the current applicant, Rita Ben, is the wife of the deceased. Accused Rajesh Bhai and Bharat Bhai are the deceased brother-in-law. According to the complaint, the deceased had a partnership with his brother-in-law, which led to disagreement over money, and the deceased left the partnership. After this, a dispute and also between husband and wife. Accused then filed a complaint under 498A against the deceased, and current complainant, who is the deceased brother. Deceased brother has not been living with the party since, I'm sorry, my lord, I'm not reading. Deceased brothers has not been living with them for the past 28 years after his marriage, I'm instructed to say. After this, the deceased went to his brother and mother, told them that the accused were repeatedly harassing him, pressurizing him to leave the house he had bought in the name of the accused Rita Ben, his wife, and threatening him. He also said that please allow me to argue. He also said that he was fed up with the harassment from the accused and wanted to commit suicide. On the day of the incident, the deceased sent an audio message in his society's WhatsApp group announcing that he was committing suicide due to harassment from the accused. Subsequently, when the deceased was admitted to the hospital, his statement to the police, dying declaration recorded by the executive magistrate, and the letter he wrote to his son and all other accused, the current defendant of the harassment. Affidavit from the investigating officer, not my statement, also stated that the deceased committed suicide due to harassment from the accused, that custodial interrogation of the accused is necessary, and that if they are released on bail, it will have a serious impact on society and public trust. Complainant submitted an affidavit stating that the deceased committed suicide due to harassment from the accused and requesting that he be not released on anticipatory bail. Considering all these circumstances as well as judgments, facts presented are not consistent with the facts of the current case as they do not help the accused. Thus, considering all the facts and circumstances, it appears that there is a prima facie case against the accused and the need for custodial interrogation is evident from the complaint. Therefore, it does not seem just to release the accused on anticipatory bail at this stage.
P06 is,
Even if the person says, I'm committing suicide because of this, it will not be enough by itself. I was just telling my brother, there was another case where I think the wife told the husband, "Jaake mar," and he went and committed suicide. Even then he was acquitted. She was acquitted. Because just merely saying to "Jaake mar" doesn't mean that he has to follow what she said.
This is all a pressure tactic that was being employed on the.
The difficulty is the abatement of suicide standard is not subjective. It has to be objective. It can't be that a person says, I'm very sensitive, so if I even hear one word of criticism, I'm going to go commit suicide. Then any person saying that I'm committing suicide because of so-and-so, if we start convicting those people on that basis, then it becomes very difficult. You need to have an objective standard.
Right, Lord, unfortunately.
He died, no doubt, but he came to you also. In fact, this is at least a case where they did not ask him to commit suicide. He came and told you that he's going to commit suicide. What did you do about it? Did you send him for counseling? You also didn't do anything. That is their case, that you knew that he was going to commit suicide and you took no steps to stop him from.
Not me, meaning the brother, not
the family. Yes. He came and told the mother and the brother that I
went and lived
fed up with my life and want to commit suicide. He tells you that I want to commit suicide. What did you do about it?
Milord, he started living with Milord, the mother and the brother.
Yeah, we'll grant protection for the time being. Let the reply come. We'll also want to see that dying declaration. Once the state comes, perhaps we'll be able to see it.
Very good.
Issue notice to the state of Gujarat, returnable on 17th September. In the meanwhile, subject to is cooperating with the investigation in FIR enforcement, so the petitioner shall not be arrested. He shall also abide by the stipulations.
Great.
May I please minutes? A closely held company, intra-family dispute, my lords have felt that it will be settled by the mediation. In the meanwhile,
mediation is before whom?
Millets,
J. Prabhakar.
Sorry?
Justice Mr. J. Prabhakar,
J. Prabha.
senior advocate in Hyderabad.
In Hyderabad.
But what are these prayers though? One prayer is to restrain the respondents from
Yes.
creating the atmosphere for mediation.
I'll provide the background.
No.
I'll provide.
What exactly are we supposed
See
to
what
say?
happened.
How are they not to vitiate the atmosphere?
My last
The
came-
second one is even worse. Restrain the respondents from lying to the banks and financial institutions. How do we restrain them from lying?
Millets, with humility, let me submit, it needs to be what you call
What are these prayers, Mr.
It should be modulated, Millets.
Yeah, very-
May I submit one thing, Millets? The difficulty is this, we are more than
At the
willing to have.
mediation table,
Yes.
and you file these applications, obviously this
No,
mediation
Millets,
is headed
the
for.
problem is this, Millets. In the name of mediation, when we have all been waiting, they go about, complain to RBI, complain to Income Tax Department, complain to all bankers who have lent money to
Finish your
and have
mediation,
been
please.
choked completely. Millets, in that context, we wanted your lordship's
There's no
intervention.
point in
Now,
the entire exercise
Millets.
if these are the kind of applications you file. during
May I
the
pray for
mediation
one thing,
process.
Millets? May I pray for you? We have provided all proof with regard to what actions they have been taking when matter has been seized up by your
They
lordship.
can mediator and say that this is what is happening, please.
Kindly see, Millets, RBI has written to them that we can't interfere. Now, Millets,
You're not considering-
kindly, Millets, let the mediation go on. I'm not coming in the
mediation
Millets,
proceedings are in.
no,
progress.
Millets.
We are not
May I seek
trying to
one thing,
entertain
Millets? Now the,
This IA seeking.
Millets, only one sentence, Millets, can I add?
Comment. It is for the parties to work out their disputes, if possible, at the mediation table.
May I submit
And
one
not
thing, Millets?
seek intervention of the court during the said process.
May I submit one thing, Millets? Only with regard, mediation, mediation, Millets.
Is lost.
Not on this point, Millets. When it comes to mediation, would my lords kindly appoint any retired
No, no, no. Why not? It's before
judge
the
of
mediator,
external
why
court
should
or the High Court?
why
So
should
that,
they interfere at this stage? How did this
No,
mediator
Millets.
come into the picture?
Millets,
Both of
so
you
far
agree.
nothing has moved. So far nothing has moved.
This court appointed. We are not to put the
No.
mediation center.
Millets, mediation center has allotted, Millets, not these your lordships.
Very well.
That's not
Whoever
correct.
it is.
Millets, at least may I pray, Millets?
Senior counsel of that court.
May I pray, Millets? I have no grievance. Only thing is, could there be a time frame, Millets? It may drag on otherwise. Kindly say that, Millets, it could be 1 month or 8 weeks, whichever way your lordship speak.
Nothing. We are not going to fix
But
that.
otherwise, Millets, they will just have their sweet time. Meanwhile, I could not get loans, I could not run the factory.
Negotiate
I'm the majority
We are
shareholder.
not going to.
It's been stifling, Millets. Can you indicate the time frame?
Sorry, Mr. Naidu. I am dismissed.
So good. Great. Millets, maybe we permitted to withdraw. Anyway, the practice, the prayer is neither here nor there. We'll just have
Having
it.
argued for some time, when senior counsel for the applicant seeks permission to withdraw the IA.
Infinix GT30.
Apply for respondent number 1 and 3 has also been filed a day before yesterday. It did not be on record.
I see, you filed a reply, right?
On behalf of R1 and R3, both are filed. And the last order had directed amended memo of parties to be filed. That has also been filed on the 19th of August.
It may not be on record,
Not filed.
it's filed. Yes.
Current counsel for the respondent number 1 states that the reply was filed on
26th of August.
20.
26th of August, 2020.
26th August. However, we do not find the same on record. Do you need to file a rejoinder to
Yes, ma'am, in 2 weeks.
current counsel?
R1 and R3 both are filed.
Appellant is permitted to file a rejoinder there.
2 weeks.
R1 and R3.
Yes.
Separate counter or?
Separate.
Replies have been filed by respondents one this week. However, we do not find the same on record. Rejoinders that we can be filed by the next February. This town so and so date, registry to verify and put up the replies by the separate. Date should be.
But it's really 2 weeks.
Give you a date. 2 weeks you want?
Yes.
No, before the next.
17th September.
Yes.
Right.